Before we begin, a quick and important disclaimer. This video provides a historical analysis of legal and social trends surrounding divorce in the 1970s for educational and entertainment purposes only. It does not constitute legal, financial, or professional advice. Laws, judicial interpretations, and social norms vary significantly by jurisdiction and have changed drastically over time. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified legal or financial professionals regarding their specific circumstances. Imagine it is January 1st, 1970. You are a man in your late 30s, living in a quiet suburb of Los Angeles. You have a steady job at an aerospace firm, a 3-bedroom house, a station wagon, and a family that, on the surface, looks like every other household on the block. For the last century, if you or your spouse wanted to end your marriage, you had to prove a crime or a moral failing. You needed evidence of adultery, physical cruelty, or abandonment. Without a villain, there was no exit. But as the clock struck midnight and the 1960s faded away, the legal ground beneath your feet didn't just shift, it completely evaporated. On that day, California's Family Law Act of 1969 went into effect, signed into law by Governor Ronald Reagan. It was the birth of no-fault divorce, a legal earthquake that would soon trigger a tsunami across all 50 states. Within a few short years, the divorce rate in the United States would double. Thousands of men who had built their lives on the assumption of a lifelong contract suddenly found themselves in a legal system that no longer required their consent to end the marriage. This was the divorce revolution, a decade of unprecedented social upheaval that redefined fatherhood, masculinity, and the American middle class. In this deep dive masterclass, we are peeling back the polyester curtain to look at the raw, often brutal reality of what it meant to be a man going through a divorce in the 1970s. We are going to explore the historical trends that led to this shift, the potential outcomes that men faced in the courtroom, and the case studies of those who were the first guinea pigs of the modern family court system. By the end of this series, you will understand exactly how the precedents set in the 1970s, from the invention of modern child support to the tender years doctrine of custody, created the blueprint for the family court system that exists today. If you have ever wondered why the system feels the way it does, or how we got to this point, you need to understand the origin story. This is the history of the disposable dad era, the alimony trap, and the decade that changed the American man forever. To truly understand the 1970s, we first have to look at the world that existed immediately before it, the fault-based system. Before 1970, marriage was legally viewed as a permanent contract that could only be breached by a guilty party. If a man wanted to leave his wife or vice versa, they had to prove a specific legal ground. This led to what historians call collusive divorces. Men and women who both wanted out would literally stage photos of adultery with hired actors just so they could present evidence to a judge. Private investigators made fortunes in the 1950s and 60s by peeping through windows to catch a fault that would allow a legal exit. It was expensive, it was embarrassing, and it was often a sham. However, the fault system provided a certain level of leverage for the innocent spouse. If a man was a good provider and had committed no fault, his wife could not easily leave him and take half his assets. Conversely, if a man was caught in an affair, the court would often punish him by awarding the wife the lion's share of the marital property. The law was designed to discourage divorce and protect the sanctity of the home. But by the late 1960s, a growing chorus of legal scholars and feminists argued that this system was archaic and forced people to lie in court. They proposed a clean break, where a marriage could be ended due to irreconcilable differences. When Reagan signed that law in California, he thought he was simply making the process more honest. He later called it one of the biggest political mistakes of his life. Why? Because the no-fault revolution removed the primary defense a man had against the dissolution of his family. For the first time in American history, unilateral divorce became possible. One partner could decide the marriage was over, and the other partner, regardless of their behavior, their effort, or their desire to stay, could do absolutely nothing to stop it. As this trend spread from California to New York and everywhere in between, the 1970s became a decade of legal chaos. Let's look at the financial impact. In 1974, the United States was hit by stagflation, a combination of stagnant economic growth and high inflation. At the same time, the divorce revolution was hitting its stride. Men who were already struggling with rising gas prices and a weak job market were suddenly hit with alimony and child support orders based on a system that had not yet adjusted to the new reality. In the 1970s, alimony, was not the temporary rehabilitative support we often see today. In many states, it was still common for a man to be ordered to pay permanent alimony to his ex-wife, ensuring she maintained the standard of living she had enjoyed during the marriage. This was based on the 1950s social contract. The man works, the woman stays home. But in the 70s, as more women entered the workforce, the courts were slow to change their math. A man earning $15,000 a year in 1975, a solid middle-class wage at the time, might find himself ordered to pay 40% of his take-home pay to his ex-wife indefinitely, while also trying to fund a second household in a decade where the cost of living was skyrocketing. Case studies from the mid-70s show a pattern of downward mobility for divorced men. While the narrative often focused on the swinging bachelor in his bachelor pad, the data suggested something much grimmer. Many men were forced into small, one-bedroom apartments or even back into their parents' homes because the financial burden of the no-fault decree was so heavy. They were the first generation of men to experience the two-household trap. Then there was the issue of custody. If the financial side was a burden, the parental side was a heartbreak. In the 1970s, the legal system operated under the tender years doctrine. This was a judicial presumption that during a child's tender years, generally considered to be up to age 13, the mother was inherently better suited to provide care. Unless a father could prove in court that the mother was unfit, which usually meant proving she was a chronic alcoholic or physically abusive, the mother was almost universally granted sole physical custody. The 1970s gave birth to the concept of the weekend dad. Men were granted visitation, typically every other weekend and perhaps a few weeks in the summer. For a man who had been a daily presence in his children's lives, this was a radical and often traumatic demotion. He went from being a head of household to a visitor in a matter of months. This shift created a psychological crisis for many American men. The 1970s saw a spike in what sociologists called paternal disenfranchisement. Men felt that if they had no say in the upbringing of their children and no physical presence in the home, their only remaining role was that of an ATM. This feeling was compounded by the cultural shift of the era. The 1970s was the me decade, a term coined by writer Tom Wolfe. The cultural focus shifted from duty and sacrifice to self-actualization and personal happiness. Movies like Kramer vs. Kramer, released in 1979, perfectly captured this tension. It showed a father, played by Dustin Hoffman, struggling to balance a career and sudden single fatherhood after his wife leaves to find herself. While the movie ended with a message of paternal capability, the reality for most men in the 1970s was much closer to the beginning of that film. A sudden, jarring loss of the life they knew, followed by a grueling legal battle to prove they were more than just a paycheck. We also have to consider the gender wars of the 1970s. This was the era of the Equal Rights Amendment, ERA debates, and the rise of second-wave feminism. While women were fighting for equality in the workplace and reproductive rights, the family court system was becoming a flashpoint for gender resentment. Men felt they were being held to old-world financial obligations, permanent alimony, while being denied old-world domestic authority and new-world parental equality. As we move through this 10-part series, we are going to look at the specific tactics used in 1970s courtrooms, the rise of the divorce industrial complex, and how the best interests of the child standard was often used as a weapon rather than a shield. We will look at how the 1970s set the stage for the Child Support Enforcement Acts of the 1980s and the joint custody movements of the 1990s. But for now, understand this: the 1970s was the ground zero for the modern male experience in the legal system. It was the decade where the rules were rewritten without a manual. The men of the 70s were the first to navigate a world where marriage was a terminal contract, where fatherhood was a privilege granted by the court, and where their financial future could be decided in a 20-minute hearing. This isn't just a history lesson. It is a diagnostic of the present. To understand why things are the way they are today, you have to understand the decade where it all began to break apart. This was the era of the Great Disconnect, and the stories of the men who lived through it provide a cautionary tale and a roadmap for every generation that followed. Let's dive deeper into the legal mechanics of the 1970s divorce court. To understand the legal mechanics of a 1970s divorce court, you have to visualize the atmosphere of a typical American courthouse in 1975. There were no digital filings, no online portals, and no automated calculators for support. Everything was recorded on carbon paper and argued in wood-paneled rooms where the smell of tobacco smoke still lingered in the hallways. When a man entered this system, he was stepping into a transition zone between two eras of American law. The old era demanded a villain, while the new era demanded an equitable split, but the judges presiding over these cases were often still rooted in the social norms of the 1940s and 50s. Imagine if you are James, a 38-year-old mid-level manager at a logistics firm in Chicago in 1976. You have been married for 15 years. You have 2 children, a 12-year-old daughter and a 9-year-old son. Your life is defined by your role as the sole breadwinner. You earn roughly $18,000 a year, which in 2026 currency would be equivalent to a comfortable middle-class salary. One evening, you return home to find a stack of legal documents on the kitchen table. You have been served. In the 1970s, being served was not just a legal step, it was a social branding. Process servers often showed up at a man's place of employment, handing over the summons in front of colleagues and supervisors. This was the first potential outcome of the new no-fault era. The sudden public collapse of a man's private life without any prior legal warning or requirement for his consent. The first legal hurdle James faces is the hearing for pendant light orders. This is a Latin term meaning pending the litigation. In the mid-1970s, these temporary orders were the most critical phase of the entire process, yet many men did not realize it until it was too late. At this hearing, a judge would determine who stayed in the family home, who paid the mortgage, and who had temporary custody of the children while the divorce proceeded. Because the 1970s still leaned heavily on the tender years doctrine, the potential outcome was almost always the same. The mother stayed in the house with the children, and the father was ordered to move out immediately while continuing to pay 100% of the household expenses. For a man like James, this created an immediate financial and psychological death spiral. He was forced to find a small apartment or stay in a motel, essentially paying for 2 households on a single salary. In 1976, with inflation hovering around 6% and heading toward double digits, the cost of maintaining a separate residence while paying the mortgage on the family home was unsustainable. This was the birth of the divorce poverty historical trend for men. James is now living in a studio apartment with a hot plate. While 70% of his paycheck is legally earmarked for a home, he is no longer allowed to enter. Step 2 of the 1970s legal gauntlet was the discovery phase. Today, we think of discovery as an exchange of digital bank statements and spreadsheets. In 1975, discovery was a grueling, paper-heavy interrogation. Lawyers would issue interrogatories, long lists of written questions, and demands for production of documents. A man was required to produce every receipt, every check stub, and every tax return from the previous decade. Because many men of that era handled the household finances exclusively, they were often blindsided by the level of detail required. If James had spent $50 on a dinner that his wife's lawyer could characterize as wasteful dissipation of marital assets, it became a weapon in the courtroom. Case studies from the American Bar Association during this period show that the financial disclosure was often used as a tool for attrition. The goal was to make the process so expensive and so invasive that the man would settle for less than favorable terms just to make the interrogation stop. This led to the rise of the specialized divorce attorney, who focused on finding the hidden money. Even if there was no hidden money, the mere accusation could lead to months of legal delays, with James paying his lawyer $75 an hour, a massive sum at the time, to prove a negative. Now we must address the most feared mechanic of the 1970s court, the alimony calculation. In 1979, the Supreme Court case of versus or finally ruled that alimony laws had to be gender-neutral, meaning men could technically receive alimony from women. However, for the vast majority of the decade, alimony was viewed as a lifelong pension for the ex-wife. The historical trend was focused on the standard of living established during the marriage. If James's wife had been a homemaker for 15 years, the court's logic was that she was unemployable in the modern economy. The potential outcome for James was a permanent alimony order. This wasn't like modern maintenance that ends after 3 or 5 years. This was an obligation that, in many states, only ended if the wife remarried or if one of them died. If James's wife chose not to remarry, James could find himself paying for her lifestyle for the next 40 years. This created the alimony trap, where a man could never truly move on or retire. In 1977, if James wanted to take a lower-paying job to reduce his stress, he would have to petition the court for a modification. But the 1970s judges were notoriously unsympathetic to men who voluntarily reduced their income. The court would often impute his previous salary, meaning he was still required to pay based on what he used to earn, not what he was currently earning. Let's look at the asset division mechanic. In community property states like California, The rule was a strict 50-50 split of everything acquired during the marriage. But in equitable distribution states, which made up the majority of the U.S., the judge had wide discretion to decide what was fair. In the 1970s, fair often meant the wife received the house and the furniture, while the husband received his pension and his tools. On paper, this might look equal, but in the context of the 1970s economy, it was anything but. The house was a tangible, appreciating asset that provided shelter and tax breaks. The pension was a future maybe that James couldn't touch for another 25 years. Furthermore, the 1970s was the era where professional degrees began to be treated as marital property. If James had gone to night school to get his MBA while they were married, his wife's lawyer could argue that the degree was a marital asset because she had supported him while he earned it. This led to enhanced earning capacity awards, where the court would calculate the projected lifetime earnings James would make because of that degree and award a percentage of that future unearned money to his ex-wife in a lump sum or increased alimony. Imagine the psychological weight of this. You are James, sitting in a cold courtroom in late 1978. You have lost your home, you see your children 4 days a month, you are paying a significant portion of your salary to an ex-spouse who may never have to work again, and you are now being told you owe her a percentage of the money you haven't even earned yet from a degree you stayed up until 2 a.m. to finish. This legal environment created a generation of ghost dads. When the financial burden became too heavy and the emotional toll of visitor status became too painful, some men simply vanished. This led to the 1975 Social Security Act amendments, which created the Federal Office of Child Support Enforcement. For the first time, the government began to use its vast data tracking powers to hunt down deadbeat dads, a term that gained national traction in the mid-70s. However, the data often failed to distinguish between men who refused to pay and men who had been economically broken by the very system we are discussing. As James walks out of that Chicago courthouse, his final decree in hand, he isn't just a divorced man. He is a man who has been legally reclassified. He is now a payer. He is a visitor. He is a non-custodial parent. The 1970s didn't just end his marriage. It dismantled his identity as a provider and a father and replaced it with a ledger of liabilities. But what happened when these men tried to fight back? What happened when they realized that the no-fault dream was actually a nightmare of procedural traps? In the next part, we are going to look at the custody war of the late 70s, the era of the private investigator, the psychological evaluation, and the specific moment when the best interests of the child became the most expensive and most contested phrase in the American legal dictionary. You won't want to miss how the 1970s invented the modern custody battle, and how it was used to leverage every single dollar a man had left. The phrase best interests of the child sounds like a moral beacon, a guiding light designed to protect the most vulnerable members of a collapsing household. But as the 1970s progressed, this legal standard often transformed into a high-stakes lever, used to extract financial concessions from men who were desperate to remain in their children's lives. Before the 1970s, the tender years doctrine was a blunt instrument. It simply assumed mothers were better for young children. By 1977, while that doctrine was being challenged as unconstitutional in various state courts, the replacement, this best interest standard, was so vague that it allowed for unprecedented levels of judicial bias and legal maneuvering. Imagine if you are Robert, a 42-year-old aerospace engineer in Seattle in 1977. You have been the primary breadwinner, but you have also been the father who coached the Little League games and spent every Sunday teaching your children how to fix a bicycle. When the divorce begins, your attorney gives you a sobering reality check. Even though the law has moved toward no fault, the courtroom still views you as a secondary parent. To the judge, you are a source of income first and a father second. If you want more than the standard every other weekend visitation, you are told that you must prove that it is in the best interests of the children. This is where the psychological warfare of 1970s custody battles began. Because there were no objective metrics for what best interests meant, the court began to rely on a new class of professionals, the custody evaluator. In 1977, this was often a social worker or an early career psychologist who would conduct a home study. For a man like Robert, this meant a stranger would enter his temporary 2-bedroom apartment to perform a visual inspection of his life. These evaluators would look for what they called indicators of stability. In the context of 1977, if Robert had a sink full of dishes, a stack of Playboy magazines on the coffee table, or if he didn't have a dedicated room for each child decorated with gender-appropriate toys, the potential outcome was a negative report. These reports were not just suggestions, they often became the definitive basis for the judge's ruling. Step by step, the legal process in these cases followed a pattern of escalating costs. First, Robert would have to pay for the evaluator, often a fee of $500 to $1,500, a massive sum when his rent was only $250 a month. Next, his wife's attorney might hire their own expert to refute the first evaluator's findings. This led to a battle of the experts, where Robert's parenting was dissected under a microscope. Historical trends show that men during this era were often scrutinized for their work schedules. If Robert worked 45 hours a week at Boeing, the court viewed his career as a liability to his parenting. The logic was circular. His wife was the better parent because she didn't work, and she didn't work because Robert provided for the family. By fulfilling his role as the provider, Robert was effectively disqualifying himself from being the primary caregiver in the eyes of a 1970s judge. Then came the private investigators. In the mid-70s, the PI industry underwent a massive shift. Since they no longer needed to catch spouses in the act of adultery to secure a divorce, they transitioned into parenting surveillance. Imagine Robert taking his kids to a park on his Saturday afternoon. Unknown to him, a man in a nondescript sedan is parked across the street with a long-lens camera using 1600 ISO film pushed in a lab to capture every moment. If Robert takes his eyes off his children for 5 minutes to read a newspaper, or if he buys them a hot dog instead of a balanced meal, that graininess and black and white photo becomes Exhibit A in a hearing to prove he is negligent or unfit. The cost of these investigators, often $25 to $50 an hour, was usually billed back to the marital estate, further depleting the assets Robert had worked 15 years to build. The most brutal aspect of the 1970s custody mechanic was the equity swap. This was an unofficial but widely practiced negotiation tactic. A wife's attorney would explicitly or implicitly suggest that if the husband gave up his claim to the house, or if he agreed to pay a higher percentage of alimony than the law required, the wife would allow him to have liberal visitation or even joint custody. In 1977, joint custody was still a radical and rare concept. California would not become the first state to pass a joint custody statute until 1979. Before that, a man had to buy his way into his children's lives. Case studies from this period reveal thousands of men who signed over their entire share of the home's equity, just to ensure they wouldn't be reduced to seeing their children 4 days a month. Historical data from the late 1970s indicates that fathers were awarded primary custody in less than 10% of contested cases. The system was designed to maintain a status quo that no longer existed in a rapidly changing social landscape. For a man like Robert, the realization that his children were being used as bargaining chips in a financial transaction was often the breaking point. This is the period where we see the rise of fathers' rights as a political movement. Men began to realize that the no-fault revolution had solved the problem of the bad marriage, but had created a much larger problem regarding the extinguished father. The psychological toll on the children was also being documented for the first time. In 1971, researchers Judith Wallerstein and Joan Kelly began a landmark study on the effects of divorce on children in Northern California. Their early findings, which would percolate through the 1970s, suggested that the absence of the father was one of the most significant predictors of long-term emotional distress for the children. Yet, the legal system continued to favor the one-home model, viewing the father as an optional accessory. By 1978, the tension had reached a boiling point. Men were tired of being Saturday dads, who were bankrupting themselves to fund a life they were no longer part of. They began to organize. They started to challenge the very foundations of the best interest standard, demanding that the law recognize their inherent right to parent. They were fighting against a judicial culture that still believed a man's only contribution to a child was a check signed on the first of the month. But as these men began to find their voice, the legal system responded with even more complex hurdles. The late 70s saw the introduction of mandatory parenting classes and mediation sessions that were often biased against the male communication style. If a man showed anger or frustration at the loss of his family, it was labeled as instability. If he remained stoic, he was emotionally distant. It was a trap with no clear exit. How did the first organized groups of men finally begin to crack the code of the family court? What happened when a small group of fathers in 1979 decided to stop paying alimony as a form of protest? And how did the government's response change the face of law enforcement in America? In the next part, we are going to look at the resistance, rise of the first fathers' rights organizations, the underground manuals that taught men how to survive the 1970s courtroom, and the specific legal strategy that finally brought joint custody to the forefront of American law. You are about to see how a few determined men in the late 70s fought to change the definition of father from a financial obligation to a fundamental right. By 1978, the silent generation of American fathers was starting to get loud. For nearly a decade, men across the United States had been blindsided by the no-fault revolution, watching as the legal ground shifted from a fault-based contract to a system of unilateral dissolution. They had watched their bank accounts drain and their parental rights wither under the tender years doctrine. But in small community centers, church basements, and rented library rooms in cities like Los Angeles, New York, and Chicago, a new kind of movement was taking shape. These were not political radicals in the traditional sense. They were engineers, salesmen, and blue-collar workers who shared a common trauma. This was the birth of the fathers' rights movement, a resistance born out of legal necessity that would ultimately rewrite the statutes of family law. Imagine if you are David, a 40-year-old high school teacher in 1978. After 3 years of legal battles, you have spent $12,000 on legal fees, which in the economy of the late 70s is nearly half of your annual salary. Your visitation has been restricted to the standard every other weekend because your ex-spouse moved 2 counties away, and the court did nothing to stop it. One night, you see a small ad in the back of a local newspaper. Divorced dads, don't lose your kids. You attend a meeting in a poorly lit basement and find 40 other men in the exact same position. For the first time, you realize your situation isn't a personal failure. It is a systemic historical trend. These men began to share what were essentially underground survival guides. In an era long before the internet, these were mimeographed newsletters and self-published pamphlets with titles like Survival for the Divorced Father. These manuals were the first step in the resistance. They detailed the specific biases of local judges, listing which magistrates were maternal-centric and which psychologists were father-friendly. Step by step, these documents taught men how to document every interaction with their children, how to keep a meticulous parenting log to counter claims of neglect, and most importantly, how to represent themselves pro se. As the 1970s economy entered a period of brutal stagflation, many men simply could no longer afford the $100 per hour fees of the growing divorce industry. The pro se movement was a direct challenge to the legal establishment. Men like David began showing up in court without lawyers, armed with their own research, demanding to be treated as more than just a source of child support. The most significant historical trend of this period was the shift from the best interests of the child being defined as stability in a single home to it being defined as frequent and continuing contact with both parents. This was not a change the courts made willingly. It was forced by activists like James Cook and the Joint Custody Association. In 1979, Cook led a push in California for the first ever joint custody statute in the United States. Before this, custody was binary. You were either the custodial parent or you were a visitor. Resistance argued for a third option: shared parental responsibility. They proposed that even if the parents lived apart, they should both retain the legal right to make decisions about the child's education, health, and welfare. The 1979 California joint custody law was a watershed moment. It didn't just allow joint custody, it created a legal preference for it if both parents agreed. However, the law contained a specific mechanic known as the friendly parent provision. This provision stated that the court, when deciding which parent should have primary custody, would look favorably upon the parent who was more likely to allow the other parent access to the child. This was a massive strategic win for men. For the first time, a father could argue that his ex-spouse's attempt to block visitation was actually evidence that she should not have custody. Men began using this as a legal shield, flipping the script on the traditional maternal preference. But the resistance wasn't just in the courtroom. It was in the bank accounts. The late 1970s saw a historical trend known as the alimony strike. In various parts of the country, groups of men began to coordinate a refusal to pay what they termed punitive alimony. They weren't refusing to support their children, but they were protesting the permanent, lifelong maintenance orders that felt like a form of indentured servitude. The potential outcomes of this protest were severe. This was the era where the term deadbeat dad was popularized by the media, often failing to distinguish between men who were truly neglectful and those who were engaged in a form of civil disobedience. In many states, the response was the use of the contempt of court power, leading to what were essentially debtors' prisons for divorced men. The case studies of these jailed fathers became rallying cries for the movement. If a man like David was jailed for 60 days for failing to pay a $400 a month alimony order, he lost his job. When he lost his job, he fell further behind. When he fell further behind, he was jailed again. It was a cycle that destroyed the very financial stability the court claimed to be protecting. The resistance used these stories to lobby state legislatures for a cap on support and the introduction of rehabilitative alimony, which would have a fixed end date. They argued that in the new era of the 1970s, where women were increasingly present in the workforce, the idea of a man paying for his ex-wife's lifestyle for 40 years was a relic of a bygone age. By the end of 1979, the cultural landscape was changing. Child psychologists like Judith Wallerstein were beginning to release data showing that children in joint custody arrangements often fared better than those in sole custody environments. The movement was gaining academic legitimacy. Men were no longer just angry, they were informed. They were leveraging the new language of psychological stability and constitutional equal protection. They were arguing that the 14th Amendment should protect their right to parent, just as it protected other fundamental civil rights. This was the moment when the definition of father began to shift from a financial obligation to a fundamental right. But as the resistance gained ground, a new counter-movement was forming. The legal system, sensing a loss of control and a loss of revenue from the divorce industry, began to tighten its grip in other ways. The federal government, concerned about the rising cost of welfare for single mothers, was preparing to step in with the most aggressive financial enforcement measures in American history. As the calendar turned to 1980, the battle was no longer just between husbands and wives, it was between the individual father and the power of the state. How did the 1980s respond to the joint custody wins of 1979? What happened when the IRS and the FBI were brought into the world of child support enforcement? In the next part, we will explore the rise of the federal enforcement era, the creation of the first national database of fathers, and the specific moment when a man's social security number became the most dangerous document in his possession. You will see how the state fought back against the resistance, turning every divorced man into a permanent digital record in the eyes of the government. The transition from a private dispute to a federal matter occurred with a precision that most American men in 1979 didn't see coming. For the first half of the decade, if a man fell behind on his support payments or moved to another state to escape an unsustainable alimony order, the legal mechanism to find him was slow, fractured, and largely ineffective across state lines. But the historical trends were shifting toward massive government intervention. The federal government was increasingly concerned about the soaring costs of the Aid to Families with Dependent Children program, known as welfare. They realized that for every dollar a father didn't pay in child support, the state was often picking up the tab. This led to the 1975 Social Security Act amendments, specifically Title 4D, which established the Office of Child Support Enforcement. To understand the weight of this, imagine if you are Mark, a construction foreman in Denver, Colorado, in late 1979. You have been divorced for 3 years. Your original decree was based on your 1976 salary, but the construction industry has slowed down due to high interest rates. You are struggling to meet your $450 a month obligation while paying rent on a drafty apartment. In the early 70s, you might have negotiated with your ex-wife or simply paid what you could. But by 1979, Mark is no longer just dealing with his ex-wife. He is dealing with a state-funded agency with the power of the federal government behind it. The potential outcomes for Mark are now dictated by a bureaucratic machine. Under Title 4D, states were given federal matching funds to establish local agencies specifically designed to locate non-custodial parents, establish paternity, and enforce support orders. The most significant tool in their arsenal was the Federal Parent Locator Service. For the first time in American history, the government began to link the social security numbers of private citizens to their domestic legal obligations. Before this, your social security number was for your retirement. By 1979, it was a homing beacon for the court. Step by step, the trap for a man like Mark would close like this. First, the state agency would use its access to Internal Revenue Service records and Social Security Administration data to find Mark's current employer. In 1979, this was a manual process that felt like a slow-motion car crash. Once located, the agency would issue a wage assignment or garnishment order. Today, in 2026, we view wage garnishment as a routine automated payroll deduction. In the late 1970s, it was a badge of shame. When a garnishment order arrived at Mark's construction firm, it didn't go to a faceless HR department in another state. It went to the owner of the company, a man Mark had worked for and respected for a decade. The historical trend in the 1970s was that a man's character was tied to his financial reliability. A garnishment order was often interpreted by employers as a sign that the employee was unstable, litigious, or irresponsible. Case studies from this era show a disturbing pattern. Men who were hit with garnishment orders were frequently the first to be laid off when work got tight. Employers didn't want the administrative headache of calculating and remitting payments to the state, and they certainly didn't want the drama of the sheriff's office potentially visiting the job site. So, the very mechanism intended to ensure the children were paid often led to the father losing the ability to pay anything at all. Furthermore, the late 1970s saw the birth of the tax refund offset program. Imagine Mark is counting on his 1979 tax refund to fix his truck so he can keep working. He files his return, expecting a check for $800. Instead, he receives a notice from the Department of the Treasury stating that his entire refund has been seized and sent to the state to cover his support arrearages. There was no hearing, no consideration of his current financial hardship, and no way to appeal the seizure before it happened. This was the first time the federal government took the role of a private collection agency for domestic debts, and it set a precedent that would only expand in the coming decades. The data from 1978 and 1979 shows that these 4D agencies were highly incentivized to be aggressive. The federal government provided what were essentially bounties to states, incentive payments based on the total amount of support collected. This created a system where the best interests of the child was frequently eclipsed by the fiscal interests of the state. If Mark's ex-wife was receiving any form of public assistance, she was required to assign her rights to child support over to the state. This meant the state was now the primary creditor. Even if Mark and his ex-wife wanted to work out a private agreement to lower the payments while he was between jobs, they couldn't. The state demanded its money to reimburse the welfare system. This created the arrearage black hole. In the 1970s, many states had laws that prevented a judge from retroactively reducing child support debt. If Mark lost his job in June and didn't get back on his feet until December, he would owe 6 months of support plus interest. Even if he could prove he had zero income during those months, the debt remained. Unlike almost every other form of debt in the United States, child support in the late 70s began to be treated as a judgment by operation of law the moment it was due. It could not be discharged in bankruptcy. It could not be negotiated away. Mark was now carrying a debt that would follow him to his grave, regardless of his future success or failure. We must also look at the criminalization of debt that began to accelerate in 1979. While the U.S. had technically abolished debtors' prisons, the 1970s family court used the civil contempt power to achieve the same result. A judge would find that Mark had the ability to pay, based on his past earnings, not his current bank balance. If he didn't pay the purge amount, a lump sum required to stay out of jail, he would be incarcerated. Once in jail, he obviously couldn't work, causing the debt to grow even faster. This was the era where the term deadbeat dad was used as a blanket label to justify the suspension of standard due process. The 1970s also introduced the concept of imputed income. If Mark decided to leave the high-stress world of construction management to become a teacher, a job that paid less but allowed him more time to see his children, the court could rule that he was voluntarily underemployed. The judge would then calculate his support based on what he could be earning as a foreman, effectively making it illegal for a divorced man to change careers or pursue a lower-paying calling. His financial identity was locked into the highest-earning moment of his marriage. As we reached the end of 1979, the American father found himself in a digital and legal panopticon. His employer, his bank, his tax return, and his very freedom were now tethered to a state-run ledger. The resistance of the mid-70s had won a few battles regarding joint custody, but the state had won the war on financial control. Men were no longer just individuals. They were account numbers in a federal database. But as the 1980s loomed on the horizon, a new and even more devastating tactic was about to emerge in the courtroom. It wasn't about money, and it wasn't about the state. It was a strategy used in the most heated custody battles to ensure a father would never see his children again, regardless of how much support he paid. It was the rise of the silver bullet allegation, the moment when the 1970s legal system realized that a single unproven accusation could do what 10 years of legislation couldn't: permanently sever the bond between a father and his child. You are about to see how the Me decade ended with a tactic that would haunt the family court for the next 50 years. The tactic was as simple as it was devastating: the weaponization of the restraining order. As the sun set on the 1970s, the legal system was undergoing a massive and necessary shift in how it handled domestic conflict. For decades, what happened behind closed doors was considered a private family matter, often ignored by police and minimized by judges. By 1976 and 1977, states began passing the first modern domestic violence statutes, providing a legal mechanism for victims to seek protection through the court. However, because these laws were drafted with a broad brush and implemented in the highly adversarial environment of no-fault divorce, they gave rise to a historical trend that practitioners began to call the silver bullet. Imagine if you are Stephen, a 42-year-old architect living in Philadelphia in 1979. You have spent the last 6 months in a contentious but civil divorce process. You have been fighting for joint custody, and your lawyer has just informed you that the judge seems inclined to grant it. You are finally seeing a light at the end of the tunnel. Then on a Tuesday afternoon, 2 sheriff's deputies arrive at your office. In front of your partners and your staff, they hand you a temporary order of protection. You are informed that you must vacate your home immediately. You are barred from contacting your wife. More importantly, you are barred from seeing or speaking to your children. You have had no hearing, no chance to tell your side of the story, and no idea what the specific allegations even are. This was the mechanic of the ex parte hearing. The term ex parte is Latin for from one party. In the legal context of 1979, it meant that a spouse could go to a judge, file a sworn statement alleging a fear of harm or a single instance of a raised voice, and the judge could issue a temporary order without the other spouse even being aware the hearing was taking place. The potential outcome for a man like Stephen was an immediate and total severance of his parental and property rights based on a single piece of paper. In 1979, the judicial culture was shifting toward a safety-first, proof-later mentality. Judges, fearful of a tragedy occurring on their watch, began to sign these temporary orders as a matter of routine. Step by step, the silver bullet would dismantle a father's legal standing. The first step was the physical removal. Stephen was given 15 minutes to gather a suitcase of clothes while deputies watched. He was then deposited on the sidewalk, locked out of his own life. The second step was the communication blackout. Because the order usually included the children, Stephen could not call to say goodnight or explain why he was gone. This created an immediate psychological vacuum that could be filled with any narrative the other parent chose to provide. In 1979, the concept of parental alienation was being observed by researchers, but it had no name and no legal remedy. The third and most tactical step was the waiting game. While the law technically required a follow-up hearing within 10 to 14 days to determine if the order should be made permanent, the 1970s court system was notoriously backlogged. Lawyers would use procedural motions to delay the hearing for weeks or even months. During this time, Stephen was a visitor in his own life, living in a motel, while his children became accustomed to his absence. This leads to a critical historical trend known as the status quo trap. When Stephen finally got his day in court 3 months later, he might have been able to prove the allegations were exaggerated or entirely false. However, the judge would then look at the children and say, "They have been living with the mother for 3 months without incident. They are settled and doing well in school. It is in their best interest to maintain the status quo." The silver bullet essentially allowed a parent to create a new reality on the ground, and then ask the court to ratify that reality after the fact. Data from the late 1970s suggests that in contested custody cases where an order of protection was filed, the filing parent was successful in obtaining sole custody in over 80% of instances. For a man like Stephen, the cost to fight these allegations was astronomical. Beyond the standard divorce fees, he now had to hire a criminal defense attorney or a specialized family litigator to conduct depositions and cross-examine the accuser. In 1979, a full-scale custody trial involving these types of allegations could cost upwards of $20,000. Roughly equivalent to $85,000 in 2026 value. Many men simply ran out of money before they could clear their names. Furthermore, the 1970s saw the implementation of the Child Abuse Prevention and Treatment Act of 1974, or CAPTA. This federal law provided funding for states to improve their child protective services and mandated that certain professionals report any suspicion of abuse. While this was a vital step for child safety, it also created a new avenue for tactical filings in divorce. A parent could call a hotline with a vague suspicion, triggering a mandatory investigation by social services. Even if the investigation eventually found the claims to be unfounded, The mere existence of a Child Protective Services file was often enough for a 1970s judge to deny a father's request for joint custody. The father was now viewed as a risk factor rather than a parent. We must also look at the social stigma of 1979. In a world before the internet, your reputation was your most valuable asset. The news of a restraining order or a social services investigation spread through suburban neighborhoods and professional circles with lethal speed. Stephen, the respected architect, was now the guy with the police at his house. This social isolation often led to a breakdown in the father's support network, making him more likely to settle for unfavorable terms just to end the nightmare. Case studies from this era show that many men signed away their pensions, their homes, and their future earnings in exchange for the withdrawal of these allegations. It was a form of legal extortion that the no-fault system was ill-equipped to handle. By the end of 1979, the American family court had become a place of extreme tactical maneuver. The high ideals of the no-fault revolution, that marriages could end with dignity and without blame, had been replaced by a system where blame was not only present, but was the most effective weapon in the arsenal. The silver bullet didn't just end marriages. It ended fatherhood for thousands of men who were unable to navigate the procedural traps of a system that prioritized administrative safety over due process. But as the 1970s turned into the 1980s, the pendulum was about to swing in a different direction. The economic reality of the 1980s, combined with a new political era under the Reagan administration, would take these local skirmishes and turn them into a national industry. The government was no longer content with just collecting support. They were about to formalize a system that would treat the American father as a perpetual debtor to the state, regardless of his relationship with his children. How did the 1980s take the lessons of the 70s and turn child support into a multi-billion-dollar bureaucratic machine? What happened when the federal government decided that every state must follow strict mathematical guidelines for support, removing judicial discretion entirely? In the next part, we are going to explore the rise of the child support industry, the era of the standardized formula, the interstate tracking system, and the moment when the American father became a primary revenue stream for the state. You will see how the 1980s turned a family dispute into a federal ledger that never forgets and never forgives. As the 1970s drew to a close, the American legal system arrived at a startling realization. The no-fault revolution had created a massive administrative nightmare. In 1970, a judge might have spent an hour listening to a man's testimony about his expenses, his debt, and his ability to pay. By 1979, the volume of divorces had increased so exponentially that the individual touch of the judiciary was being replaced by the cold, hard logic of the algorithm. This was the birth of the standardized child support formula, a mechanic that would eventually strip away judicial discretion and replace it with a grid. To understand the world of a man in 1979, you have to understand the transition from the subjective to the mathematical. Imagine if you are Thomas, a 44-year-old foreman at a tool and die shop in Michigan in 1980. You have been through the 1970s legal grinder. You lost your home in 1976, you've been paying alimony for 4 years, and you are now facing a modification hearing because your ex-wife's attorney has cited the rising cost of living. In 1975, a judge might have looked at your stagnant wages and the fact that you are living in a trailer and denied the increase. But by 1980, Michigan and several other states were beginning to experiment with what would become the income shares model. This wasn't just a suggestion, it was becoming the law of the land. The income shares model was based on a simple, yet arguably flawed economic premise. A child should receive the same proportion of parental income that he or she would have received if the parents had lived together. Step by step, the court would now calculate this. First, they would take Thomas's gross income. Second, they would take his ex-wife's income, which was often zero or significantly lower in 1980. Third, they would look at a pre-calculated table, developed by economists at the Department of Health and Human Services, to see what a typical family of that income level spent on a child. Finally, they would prorate that amount between the parents. The potential outcome for Thomas was a mathematical certainty that ignored his actual reality. The formula did not care that Thomas had a 14% interest rate on his car loan because of the Volcker-era inflation. It did not care that his heating bills in a Michigan winter had tripled. The formula was an average, and Thomas was being squeezed by an average that didn't account for the specific financial wreckage of his post-divorce life. This historical trend marked the moment where the individual was removed from the family court. You were no longer a father with a unique set of circumstances, you were a data point on a fiscal grid. This period also saw the rise of the Melson formula, pioneered in Delaware around 1979. This was even more complex. It attempted to calculate a self-support reserve, a bare minimum amount of money a father was allowed to keep for his own survival before the child support was calculated. While this sounded fair on paper, the reserve was often set at or near the federal poverty line. For a man like Thomas, who had been a middle-class provider his entire life, the potential outcome was a legal decree that he was officially allowed to live in poverty, so that the state could ensure the marital standard of living was maintained in the other household. We must look at the incentive structure that was formalized as the 1970s became the 1980s. Under the 1975 Social Security Act amendments, the federal government began paying states a commission for every dollar of child support they collected. By 1980, this had turned into a massive state-level industry. States were not just collecting money for children, they were collecting money to fund their own bureaucracies. For every dollar Thomas paid through the state's centralized collection unit, the state received a federal matching grant. This created a historical trend where the state had a direct financial interest in keeping child support awards as high as possible. The more Thomas was ordered to pay, the more federal money the state agency received. Case studies from 1980 and 1981 reveal that this led to the administrative escalation. State workers, incentivized by federal quotas, became aggressive in seeking upward modifications. If Thomas received a 2% cost of living raise at the tool and die shop, the state's 4D agency would often be the first to know, thanks to the new interstate data sharing systems. They would then petition the court to increase his support, often before Thomas had even seen the extra money in his own paycheck. This was the financial panopticon in its early analog form. Now let's look at the interstate trap. In the 1970s, if a man moved from Michigan to Texas to find work, the reach of the local court was limited. But the 1980s saw the full implementation of URESA, the Uniform Reciprocal Enforcement of Support Act. By 1981, this meant that a court in Michigan could command a court in Texas to garnish Thomas's wages, seize his bank accounts, and even put a lien on his property. There was no escape from the ledger. Even if Thomas moved to a state with a lower cost of living, his support was still tied to the Michigan formula, which was based on a completely different economic reality. Imagine if you are Thomas, and you finally managed to save $1,000 for a down payment on a small house in 1981. You wake up to find your bank account has been levied, frozen and drained by a state agency you haven't spoken to in 3 years. They claim you owe arrearages from a period in 1978 when you were laid off. Because of the Bradley Amendment, which was being drafted during this era and passed shortly after, these debts were becoming vested judgments that could never be reduced or forgiven, even if the state was wrong about the math. The 1980s also introduced the concept of criminal non-support as a high-priority enforcement tool. In the 1970s, being behind on support was a civil matter. By 1982, it was increasingly being treated as a felony. The historical trend shifted from helping the family to punishing the debtor. This led to the creation of most wanted lists for parents, where a man's face could be plastered on a billboard or a television screen for being behind on payments, often payments that had been inflated by interest and state-mandated penalties that could exceed 12% per year. As we look back from the year 2026, we can see that this was the decade when the humanity of fatherhood was fully collateralized. The 1970s broke the marriage, but the transition to the 1980s broke the man's financial autonomy. Thomas was no longer a father who visited his children. He was a revenue stream for a state-federal partnership. The best interests of the child had been successfully rebranded as the efficient collection of debt. But there was a darker, more personal side to this transition that the formulas couldn't capture. As the financial trap closed, the mental health of American men began to collapse in ways the 1970s hadn't predicted. The combination of visitor status, the silver bullet allegations we discussed in Part 6, and the financial panopticon created a perfect storm of despair. What happened when the 1980s legal system met the breaking point of the human spirit? How did the divorce revolution lead to a hidden epidemic of male isolation, and what sociologists now call deaths of despair? In the next part, we are going to dive into the silent crisis, the psychological impact of the 1970s divorce laws on the men who were left behind. We will look at the rise of support groups, the specific trauma of parental alienation, and the moment when the American man realized that in the eyes of the law, he was worth more as a debtor than as a dad. You won't want to miss this deep dive into the emotional cost of the polyester decade. The psychological landscape of the late 1970s was a battlefield where the casualties were often the very men who had been told that liberation would benefit everyone. While the cultural zeitgeist of the Me decade celebrated the idea of shedding old skins and finding one's true self, the reality for a divorced father in 1978 was often a descent into a profound and silent isolation. The legal mechanics we have discussed, the financial panopticon, the silver bullet allegations, and the reduction to visitor status did not just happen in a vacuum. They occurred within a human being who had been socialized in the 1950s and 60s to believe that his identity was inextricably linked to his role as a provider and a protector. When the court stripped those roles away, it didn't just take his house, it took his reason for being. Imagine if you are Michael, a 45-year-old insurance adjuster in 1979. In 2026, we look back at Michael's era through a lens of nostalgia. But for him, the year 1979 is a gray blur of survival. Michael has followed the historical trends of the era to the letter. He moved out of the family home in 1977 to a one-bedroom apartment in a complex specifically marketed to singles. The 1970s myth of the swinging bachelor was everywhere in the media, from movies to magazine ads, suggesting that Michael should be enjoying a new lease on life with a bar cart and a stereo system. But Michael represents a far more common case study. He isn't swinging, he is drowning. Every other Friday, Michael drives his 1977 Chevy Nova to the house he used to own. He sits in the driveway, heart racing, waiting for his children to walk out the door. This is the ritual of the weekend dad, a role that Michael finds increasingly impossible to play. Step by step, the psychological erosion of this arrangement begins. First, there is the pressure of the Disneyland dad phenomenon. Because Michael only has 48 hours with his children, he feels he cannot be a real parent. He cannot enforce bedtimes, he cannot help with long-term homework projects, and he cannot have the quiet, boring moments of daily life that actually build a bond. Instead, he feels he must perform. He spends money he doesn't have on movies, fast food, and toys, trying to compress 2 weeks of fatherhood into 2 days. The potential outcome of this performance is a profound sense of fraudulence. Michael feels like an uncle, not a father. Historical data from this period shows that as the 1970s progressed, a significant number of men began to withdraw from their children not out of a lack of love, but out of a sense of unbearable pain. The contrast between the life they once had and the visitor status they were granted was too sharp to endure. For Michael, every Sunday evening drop-off is a fresh trauma. He returns to an empty apartment where the silence is deafening. In 1979, there were no online forums for men to share their experiences. There were number 24-hour mental health hotlines targeted at fathers. There was only the bar, the job, and the crushing weight of the next support payment. This era saw the emergence of a specific psychological phenomenon that would eventually be studied in depth: parental alienation. While the term was not yet part of the standard legal lexicon in 1979, the mechanics were in full swing. Because the 1970s legal system was so adversarial, it incentivized the custodial parent to portray the non-custodial parent as unnecessary or even dangerous. Michael's children start coming to his weekend visits with stories they've been told: that dad left because he didn't love them, or that mom is struggling because dad is taking all the money. In 1979, Michael had no legal recourse for this. If he complained to the judge, he was told to stop being bitter. If he tried to explain his side to the children, he was accused of poisoning them. He was caught in a psychological hostage situation where the only way to keep the peace was to accept his own erasure. The historical trends regarding male mortality in the late 1970s tell a grim story. Research from that period indicated that divorced men were significantly more likely to suffer from heart disease, clinical depression, and what we now call deaths of despair. The suicide rate for divorced men in the late 70s was several times higher than that of married men or even divorced women. In a society that still largely expected men to be stoic and self-reliant, the loss of family structure left Michael without a safety net. His social circle, which had been primarily composed of other married couples, evaporated. He was the odd man out, a reminder of the fragility of the suburban dream. We must also consider the role of early support groups like the one Michael might have found in 1980. These were the first men's liberation groups, inspired by authors like Warren Farrell. They began to argue that the 1970s had traded one form of sexism for another. They pointed out that while women were being liberated from the kitchen, men were being locked more tightly into the role of the wallet. These groups provided a vital lifeline, but they were often dismissed by the mainstream media as being composed of angry, regressive men. In reality, they were the only places where Michael could admit that he was lonely, that he missed his children, and that he felt the legal system viewed him as disposable. Case studies from the end of the decade show that the psychological impact extended into the workplace. Michael's productivity began to slip. His supervisors, who in 1975 might have been sympathetic, were now part of a corporate culture that was becoming more bottom-line focused as the 1980s approached. A man going through a messy divorce was seen as a liability. The stress of the silver bullet allegations, the constant fear of a wage garnishment, and the lack of sleep from living in a cramped apartment led to a downward mobility that was as much psychological as it was financial. By 1981, Michael is a different man than he was in 1970. He is thinner, more cynical, and he has a strained relationship with children who have grown up seeing him as a Friday night guest, rather than a pillar of their lives. He has survived the divorce revolution, but he has been fundamentally changed by it. He is the blueprint for the modern alienated father, a man who paid every cent he owed but lost the very thing he was paying to protect. But what about the children? As the 1970s turned into the 1980s, the first generation of no-fault children was reaching adulthood. The legal system had made its decisions based on the best interests of the child, but what did the children actually have to say about it 20 years later? In the next part, we are going to dive into the landmark Wallerstein study, the 25-year deep dive into the lives of children of divorce. We will explore the long-term impact of the 1970s visitor dad model, and the shocking data that would eventually force the legal system to rethink everything it thought it knew about custody and stability. You will see how the legacy of the 1970s divorce court didn't just end with the parents. It reshaped the psyche of an entire generation of Americans. The long-term impact of the 1970s divorce revolution is perhaps most visible in the children who grew up during that era of legal experimentation. While the fathers of the 70s were grappling with the financial panopticon and the loss of their homes, a generation of American children was being raised under a social and psychological theory that had never been tested. The prevailing wisdom of 1972 was that children would be fine as long as the fighting stopped. Judges and psychologists argued that a stable home with one parent was far superior to a conflict-ridden home with two. This belief was the cornerstone of the sole custody model that dominated the decade. But as the years turned into decades, the data began to tell a far more complex and troubling story. In 1971, clinical psychologist Judith Wallerstein began a study in Marin County, California, that would eventually become the most influential piece of longitudinal research in the history of family law. She tracked 60 families through the 1970s, conducting intensive interviews with both parents and children at various intervals: 5 years, 10 years, 15 years, and eventually 25 years post-divorce. What Wallerstein discovered was the sleeper effect. This was a phenomenon where children of the 1970s appeared to be coping well during their teenage years, only to experience a sudden collapse in their emotional stability and relationship success once they reached their 20s and 30s. Imagine if you are Christopher, born in 1969 in a suburb of Philadelphia. In 1976, when you were 7 years old, your parents went through a no-fault divorce. Following the historical trends of the era, your mother was granted sole custody of you and your younger sister, and your father was moved into the visitor role. Step by step, the daily intimacy of your relationship with your father was dismantled. He was no longer the man who helped you with your math homework or showed you how to use a hammer. He was the man who arrived every other Friday in a different, smaller car to take you to a movie or a pizza parlor. For Christopher, the potential outcome of this arrangement was a slow-motion estrangement. In the 1970s, there was no concept of shared parenting time. When your father moved to a different apartment, and eventually a different city for work, the legal system did nothing to maintain the bond. Case studies from this period show that by 1981, many of these visitor dads had become peripheral figures. Christopher began to feel like a guest in his father's life and a protector in his mother's. This led to what researchers call parentification, where the child of a 1970s divorce felt a heavy responsibility to care for the emotional well-being of the custodial parent. Christopher grew up fast, but he grew up without a roadmap for what a healthy adult male-female partnership looked like. By the time Christopher reaches the year 2026, he is 57 years old. He is part of the first generation to have lived through the full life cycle of the no-fault era. Looking back from 2026, Christopher can see the historical trends in his own life. He struggled with commitment in his 20s. He felt a deep-seated anxiety that any relationship he built was inherently fragile and could be unilaterally dissolved at any moment, just as his family had been in 1976. Wallerstein's research supported this, finding that the children of the 1970s were often terrified of failure, leading them to either avoid marriage altogether or to enter it with a sense of impending doom. The data from the Wallerstein study and subsequent research by figures like E. Mavis Hetherington provided the first real evidence that the 1970s legal model was flawed. The visitor-dad model, while administratively simple for the courts, was psychologically devastating for the children. The lack of a daily male presence had specific impacts on the boys of the 1970s, who often struggled with authority and identity, and the girls who often sought male validation in precarious ways during their adolescence. The historical trend was clear. The best interests of the child had been interpreted as a financial and logistical convenience, but the emotional interests of the child had been largely ignored. Step by step, this realization began to change the legal landscape. By the late 1980s and early 1990s, the findings from these 1970s children were being cited in state legislatures to argue for joint custody. Lawyers and advocates pointed to the Christopher case studies to show that a father's value was not in the child support check he mailed once a month, but in his physical presence in the child's life. The 1970s had treated fathers as optional accessories, but the adult children of the 1970s were testifying that their fathers were essential. Furthermore, we must look at the economic legacy for these children. The 1970s divorce often led to a significant drop in the standard of living for the children. While the alimony and child support formulas were designed to maintain the status quo, the reality was that two households could not be run as cheaply as one. Children of the 70s were the first to experience the latchkey kid phenomenon on a massive scale. With the father gone and the mother forced into the workforce to make up for the lost income, an entire generation of Americans grew up with unprecedented levels of unsupervised time. This wasn't the liberation the 1970s promised. It was a grueling survival tactic for broken families. Case studies from 1979 also highlight the impact of the relocation trend. Because there were almost no legal restrictions on a custodial parent moving with the children, many fathers of the 1970s lost contact simply because the mother moved 500 miles away for a new job or a new relationship. For a child like Christopher, this was the final blow. The visitor dad became the Christmas card dad, and eventually the stranger dad. This total severance of the paternal bond is one of the most tragic and least discussed historical trends of the no-fault era. As we look at the legacy of these children in 2026, we see a generation that has fought to do things differently. The men who were children of the 1970s are often the most vocal advocates for equal shared parenting today. They are the ones who refuse to be visitors. They are the ones who understand from their own lived experience that a father is not a paycheck and a child is not a bargaining chip. They are the living evidence of the 1970s failure, and they have spent their adult lives trying to build a system that values the bond over the bureaucracy. But even as these lessons were being learned, the legal system was already moving toward its final and most rigid form. The 1970s had been a decade of chaos and experimentation, but the 1980s and 90s would bring a level of institutionalization that would make the early no-fault years look flexible by comparison. How did the 1970s lead to the modern family court crisis we see in 2026? What is the final verdict on the decade that promised freedom but delivered a new kind of confinement for the American man? In the final part of this masterclass, we are going to pull it all together. We will look at the ultimate cost of the divorce revolution, not just in dollars but in the soul of the country. We will explore the final historical trends that connect the 1970s to the present day, and offer a final analysis of how a man can navigate the legacy of this polyester decade. You won't want to miss the conclusion of our deep dive into the history that redefined masculinity and the American home forever. To look back from the year 2026 is to see the 1970s not just as a decade of disco and denim, but as the era of the Great Dislocation. We have spent 9 parts dissecting the legal mechanics, the psychological warfare, and the financial traps that were laid for American men during this pivotal decade. Now, in this final masterclass, we must address the ultimate legacy of that era: the birth of the state as a silent, permanent third party in the American marriage. The 1970s didn't just change how marriages ended, it fundamentally changed what it meant to be a man in the eyes of the United States government. Imagine if you are Gary, a 75-year-old retired civil engineer living in a quiet suburb of Phoenix in April 2026. You were 31 in 1982, right at the tail end of the polyester decade's legal fallout. You divorced in 1978, a year when the no-fault revolution was hitting its absolute peak. Looking back from your porch today, you can see the historical trends of the 1970s reflected in your own bank account and your own family tree. Gary is the case study for the long-term survival of the 1970s man. He is a man who saw his net worth cut in half by a judge, who used the equitable distribution standard to award the family home to his ex-wife, while Gary was left with the mortgage debt and a car he couldn't afford to fix. The first major legacy we must analyze is the shift from the social contract to the administrative decree. Before 1970, marriage was a contract between two people, overseen by a community and a church, where fault was a moral compass. The 1970s replaced morality with actuarial science. Step by step, the legal system removed the concept of individual agency and replaced it with a series of preset potential outcomes. For Gary, this meant that his behavior as a faithful, providing husband was legally irrelevant the moment his wife decided to file for no-fault divorce. The historical trend was the commodification of the household. The home, the children, and the future earnings were no longer parts of a family. They were assets to be liquidated and redistributed by a state-appointed official. The financial data from the 1970s reveals a staggering reality that Gary still feels in 2026. Between 1970 and 1980, the number of men living alone in the United States increased by nearly 60%. This was not because men wanted to be alone. It was because the 1970s divorce court created a massive class of transitory men. These were men who were moved out of their homes and into apartments, motels, and even their parents' basements. The economic impact was a permanent drag on male wealth accumulation. In Gary's case, the $40,000 in equity lost in 1978, if adjusted for inflation and standard market returns of 7% annually, would represent over $600,000 in 2026. The 1970s divorce wasn't just a temporary setback. For millions of men, it was a lifelong structural handicap that prevented them from reaching their full potential in retirement. We must also deep dive into the best interest standard as a tool for institutional growth. In the 1970s, the legal system realized that by making divorce easier to start but more complicated to finish, they could expand the footprint of the judicial branch. This was the birth of the divorce industrial complex. Lawyers, custody evaluators, psychologists, and state enforcement agents all found a permanent revenue stream in the conflict between fathers and mothers. For a man like Gary, the 1970s courtroom wasn't a place of resolution. It was a place of perpetual litigation. Historical trends show that once a man entered the 1970s family court system, he was likely to return to it at least 3 times over the next decade for modifications, contempt hearings, or enforcement actions. The state became a landlord in the father's life, collecting a tax in the form of child support and alimony that was enforced with the threat of imprisonment. Let's look at the psychological erasure of the American father. In 1970, the father was the head of household. By 1979, the legal system had rebranded him as the non-custodial parent. This was more than just a linguistic shift, it was a psychological demotion. Gary remembers the feeling of being a guest in his own children's lives. He remembers the 1970s court-ordered visitation schedules that treated him as a weekend distraction rather than a developmental necessity. The potential outcomes of this erasure were profound. A generation of children who grew up viewing their fathers as optional, and a generation of men who felt their only remaining value was their ability to generate a paycheck. This is what sociologists call the disposable dad trope, and it was engineered in the wood-paneled courtrooms of the 1970s. Furthermore, the 1970s set the stage for the massive federalization of domestic law. Before 1975, your divorce was a local matter. By 1979, because of the Social Security Act amendments we discussed in Part 5, your divorce was a matter of federal record. The 1970s was the decade that taught the government how to track private citizens through their domestic obligations. This created a blueprint for the surveillance state of the 1990s and 2000s. Gary's Social Security number, once a tool for his retirement, became a tool for his tracking. This historical trend toward total enforcement meant that for the American man, there was no longer any such thing as a clean break. You were tethered to the state through your ex-spouse and your children for the rest of your natural life. As we stand in 2026, we see the results of this 50-year experiment. The fatherless crisis that dominates social discourse today can be traced directly back to the 1970s judicial preference for sole maternal custody. The male loneliness epidemic that we see in 2026 has its roots in the social isolation of the 1970s divorced bachelor. Gary is one of the lucky ones. He managed to rebuild a life, but many of his peers did not. They became the ghost dads and the broken providers of a decade that promised them liberation but gave them a ledger of debt. The 1970s was the laboratory, the American father was the subject, and the family court was the scientist. The goal was to modernize the American family, but the result was a system that valued administrative efficiency over human connection. For a man navigating the world today, understanding the 1970s is the only way to understand why the system feels rigged, why the fees are so high, and why the best interests of the child so often feel like the best interests of the bureaucracy. This concludes our deep dive masterclass into the 1970s. We have uncovered the polyester trap, the alimony minefield, and the silver bullet allegations. We have seen how a man's identity was dismantled in a decade of polyester and transition. But the story doesn't end here. The 1970s were just the beginning. As the calendar turned to 1980, a new era of greed is good and aggressive enforcement was about to take the foundation laid in the 70s and turn it into a multi-billion-dollar government industry. What happens when the 1980s introduces the child support bounty system? How did the Reagan era turn the deadbeat dad from a social nuisance into a national enemy number one to justify even more invasive laws? In our next deep dive series, we are moving into the neon-soaked decade of the 1980s, where the stakes get higher, the technology gets smarter, and the trap for the American man becomes a digital fortress. You think the 70s were tough? You haven't seen the 1984 Child Support Enforcement Amendments. Stay tuned, because the history of the 1980s divorce is about to reveal exactly how we arrived at the digital panopticon of 2026.